Hi everyone, this is trademark attorney Josh Gerben. One question we get almost every day from prospective clients is my trademark too general? And the question is a good one, and basically what it means is my trademark unique enough to be protected with a federal trademark registration? Because ultimately, in order to obtain a trademark registration, your trademark has to have a certain level of uniqueness in your industry. So let's take an initial example, and then I'll go into all the technical details that you might want to consider. But the initial example is the word apple. If I were to be launching a new brand of apples, like I had an apple farm and I wanted to brand my apples something, if I just called them green apples, and they were in fact green apples, there would be no way I could protect that trademark. However, if I were to launch a new computer company and want to call my brand of computer a green apple computer, that would be an extraordinarily unique trademark and very protectable. Just take a look at Apple computers. So you could see the same word could be too general or too generic in one industry, but work very well in another. So with that in mind, you should know that trademarks come on a sliding scale of protectability. And here's what the scale looks like. It starts at the very bottom with generic trademarks or trademarks that are too general to be enforced. The next step up is a descriptive trademark. It's a trademark that describes your goods or services and is considered very weak and will only be able to be registered on the supplemental trademark register as opposed to the principal trademark register, which is where the most unique trademarks go to be registered. A step up from a descriptive trademark is a suggestive trademark. This is a trademark that has met enough unique qualities to be considered eligible for the principal register. Above suggestive trademarks are arbitrary trademarks and fanciful trademarks. So let's go through some examples for each one of these. A generic trademark would be like the example I gave about green apples for a brand of apples. A descriptive trademark might be scrumptious apples, right? I'm describing that they're very scrumptious, but that is not that unique of a word. However, if nobody else had branded their apples as scrumptious apples, I might be able to obtain a very limited supplemental register registration on my trademark. What this means is that a court may have a very difficult time actually enforcing the trademark, but I can get a registration and maybe deter others from using that name for that particular product. Next up on the list is suggestive trademarks, and this is typically the sweet spot. This is where you want to be because you're allowed to tell consumers something about your trademark, just not describe it. A great example here is Netflix. They combine the word internet with the word flicks, which is something that we kind of call movies, right? We say, oh, in olden days at least, right? So Netflix, it describes that it's flicks available on the internet, but doesn't just tell you that's what it is. Another good example here would be AIRBUS, the plane company. It's something in the air that acts like a bus, but it's, so you see, it suggests that it will take you from place to place like a bus. It'll do so in the air, but they've combined those two words to create something new, AIRBUS. And that's a great suggestive trademark. Next up on the list is arbitrary trademarks. And these are trademarks that are actual words, but just have nothing to do with the product or service. Think of Apple for a brand of computers. Going back to that example, right? And Apple has nothing to do with a computer, but it's a very common word in the English language. That would be an arbitrary trademark for a brand of computers. And finally, we have fanciful trademarks. These are just completely made up words. And these are hard to do, but they're the most protectable trademarks because they're going to be the most unique. Think of KODAK. KODAK was a completely made up word, and it's an extraordinarily protectable trademark. So I hope this kind of helps you understand that trademarks come on a sliding scale protectability, and the more unique you are in creating your name, the more protection you can expect down the road in your trademark. If you have any further questions, please feel free to get in touch with us. Just go to gerbenlaw.com and go to the contact page on our website. Be happy to answer any further questions you may have. Take care, and I'll talk to you next time.